Consequently, the decisions declaring that informal marriages are valid marriages could not have been decided per incoram. Section 32 of the Evidence Act also states that a child born during the marriage of the mother is presumed to be the child of the person who is the husband of that mother at the time of the birth. A child of a woman who has been married, born within 300 days after the end of the marriage, is presumed to be a child of that marriage. The section also applies to both monogamous and polygamous marriages. Dissolution of a monogamous marriage. Divorce refers to a mode of dissolution of the marriage contract, a formal termination of the status derived from marriage. So that, following the grant of a decree, both spouses have neither the duties nor the rights of husband and wife. The dissolution of marriages is governed by the Matrimonial Causes Act, 1971, Act 367. Section 1(1) of the MCA allows either party to a marriage to present a petition for divorce to the court. Per Section 31 of the MCA, either party to the marriage must either be a citizen of Ghana, domiciled in Ghana, or has been ordinarily resident in Ghana for at least 3 years immediately preceding the commencement of the proceedings. Grounds for the grant of a divorce petition. Per the Matrimonial Causes Act, 1971, the sole ground for granting a petition for divorce by the court is proof that the marriage has broken down beyond reconciliation. There are restrictions on the time for filing a divorce petition. Per Section 9(1) of the MCA provides that no petition for divorce shall be presented to the court within 2 years from the date of the marriage. However, per Section 9(2), the court may, on application, allow the presentation of a divorce petition within 2 years from the date of the marriage on the grounds of substantial hardship suffered by the petitioner or depravity on the part of the respondent. Substantial hardship occurs when, for example, one of the parties constantly beats the other or threatens to kill him or her. In such situations, the courts will not wait for 2 years before granting the petition for divorce. Depravity describes a situation where, for example, a husband demands that the wife have sex with a third party in his presence or demands a threesome. In Section 9(3), it is stated that in determining the application under subsection 2, the court shall have regard to the interest of any child of the household and to the question whether there is a reasonable possibility of reconciliation between the parties. Also, Section 9(4) provides that if it appears to the court that leave under subsection 2 was obtained by the petitioner by any misrepresentation or concealment of the nature of the case, the court may dismiss the petition without prejudice to any petition which may be brought after the expiration of the period of 2 years from the date of that marriage upon the same, or substantially the same, facts as those proved in support of the dismissed petition. Finally, Section 9(5) provides that the section shall not be deemed to prohibit the presentation of a petition based upon matters which occurred 2 years from the date of the marriage. To prove that the marriage has broken down beyond reconciliation, Section 2(1) of the MCA provides that the petitioner must establish any of the following grounds: a. that the respondent has committed adultery and that by reason of that adultery, the petitioner finds it intolerable to live with the respondent. Adultery refers to sexual intercourse between 2 persons of whom one or both are married but who are not married to each other. Section 43 of the MCA also defines adultery as the voluntary sexual intercourse of a married person with one of the opposite sex other than his or her spouse. To establish adultery, there must be at least partial penetration of the penis of the man into the vagina of the woman. An unsuccessful attempt at sexual intercourse would therefore not qualify as adultery. Further, masturbation and artificial insemination by a donor would not qualify as adultery. Sexual intercourse must have been consensual. Therefore, if intercourse occurs as a result of rape, there would not have been adultery. The presence of disposition and opportunity may lead the court to conclude that adultery has been committed. Opportunity alone is not enough. Therefore, a court must be satisfied that there was something more than opportunity before it will affix guilt, plus there must be evidence of inclination and passion. In Story v. Story Laycock, the husband had a violent quarrel with his wife, who then went to live in the house of her male first cousin. It was held that there was no presumption of adultery simply because opportunity was there. Where the petitioner alleges adultery, he or she does not need to provide direct evidence of adultery, since direct evidence of adultery is difficult to find. Adultery may therefore be inferred from circumstances which by fair and necessary inference lead to that conclusion. For instance, the courts have inferred adultery where blood tests revealed that a child is not the petitioner's child. In Agidi v. Agidi, the parties lived at Kanda in Accra. The respondent built a house at Teshi and they agreed to move in. On the day that they moved, they agreed that they would go in separate cars. The respondent never drove to Teshi. Instead, she drove to her boyfriend's house. Her uncle subsequently brought her back to her husband after 2 months, but she escaped and never returned to the matrimonial home. The court decided that from the circumstances of the case, it could be inferred that adultery had been committed and that the marriage had broken down beyond reconciliation. Also, in Blum v. Blum, the respondent booked a double room in a hotel with a woman who was not his wife. The court held that adultery could be inferred. Further, in Wolf v. Wolf, it was held that there is a rebuttable presumption of adultery which will be raised by the parties spending the night in the same room. Confession may be used to establish adultery. However, a confession made under duress will not be admissible. In Carty v. Carty Ainer, the husband petitioned for divorce on the ground that the wife had committed adultery. The wife denied the allegation and stated that the confession she made was under duress. She further explained that when she denied the accusations, the husband beat her severely and that she admitted the adultery to stop the husband from beating her. The court held that adultery had not been proved, and the petitioner had contracted a sexually transmitted disease from the respondent. Adultery may be inferred. In Carty v. Carty and another, the court noted that the burden of proving adultery lies on the person who alleges it and it cannot be shrugged off by evidence that is tainted, indifference, suspicious or uncertain. The standard of proof required is proof beyond reasonable doubt, that is, it must be proved with the same degree of strictness as is required for the proof of a criminal offense. In Agidi v. Agidi, the court departed from the proof beyond reasonable doubt approach and stated that adultery must be proved by to the satisfaction of the court and must carry a high degree of probability because adultery is a serious offense. Adultery was also inferred in a case where a husband went to a hotel with a woman who was not his wife and booked a double-bed room in a false name. It must also be noted that the petitioner must prove that, in addition to the adultery, she finds it intolerable to live with the respondent. This is a subjective test. Therefore, the court must find out whether the particular petitioner finds it intolerable to live with the respondent and not what a reasonable petitioner would have found intolerable. It is important to note Section 3 of the MCA, which states that where with a view to reconciliation the parties to the marriage have lived with each other as man and wife for a period or periods after it became known to the petitioner that the respondent had, since the celebration of the marriage, committed adultery, then, a. if the length of that period or of those periods together was 6 months or less, their living with each other as man and wife during that period or those periods shall be disregarded in determining whether for the purposes of Section 2(1)(a), the petitioner finds it intolerable to live with the respondent, but, b. if the length of that period or those periods together exceeded 6 months, the petitioner shall not be entitled to rely on that adultery for the purposes of Section 2(1)(a). The parties must live together as husband and wife for the section to apply. Therefore, if a wife leaves the matrimonial home as a result of the husband's adultery but returns and stays there for 10 months to nurse him after a car crash, the wife can still rely on the adultery. She returned to the matrimonial home to care for the husband and not to live with him as a wife. Section 12 of the MCA provides that the person alleged to have committed adultery with the party to the marriage may but need not be made a party to the proceedings. b. that the respondent has behaved in a way that the petitioner cannot reasonably be expected to live with the respondent. The test applied by the courts in this case is a cross between a subjective and an objective one. The courts therefore consider whether a hypothetical reasonable spouse would continue to live with the respondent if faced with the same circumstances the petitioner faces. As stated in Livingstone-Stallard v. Livingstone-Stallard, would any right-thinking person come to the conclusion that this husband has behaved in such a way that his wife cannot reasonably be expected to live with him, taking into account the whole of the circumstances and the characters and personalities of the parties? The test was even more fully spelt out in Ash v. Ash, where Bagnall J. stated, "I have to consider not only the behavior of the respondent, but the character, personality, disposition and behavior of the petitioner. The general question may be expanded thus: can this petitioner, with his or her character and personality, with his or her faults and other attributes, good and bad, and having regard to his or her behavior during the marriage, reasonably be expected to live with this respondent?" Reference may therefore be made to personalities of the parties, the nature of the respondent's conduct, and the character and physical and mental weaknesses of the parties. It is also important to note that mere trivialities which can be considered as the reasonable wear and tear of married life would not suffice. Unreasonable behavior has been defined in English law as conduct that gives rise to injury to life, limb, or health, or conduct that gives rise to a reasonable apprehension of such danger. According to this definition, therefore, actual injury does not have to be established. Mere apprehension of such injury is enough so far as it has led to the breakdown of the marriage beyond reconciliation. Some behaviors that the court have held to be unreasonable include refusal of sexual intercourse or the practice of coitus interruptus or persistent inordinate sexual demands, homosexual activities, persistent drunkenness and addiction to gambling, bullying or constant criticism, willful or reckless infection with venereal disease, threats or actual physical and emotional abuse to the spouse or their children. Note that in cases of threats or actual physical abuse, the spouse is encouraged to report to the Domestic Violence and Victim Support Unit of the Ghana Police Service to ensure that adequate protection is given to that spouse and children until the determination of the divorce suit. Persistent verbal abuse, destroying petitioner's property and causing the wrongful arrest of the petitioner. Note that per Dowden v. Dowden, it is state that inability to have sexual intercourse as a result of impotence does not amount to unreasonable behavior. In Hap P v. Hap P and another, the husband, a native of Netherlands, was the petitioner. The respondent was the Ghanaian wife of the petitioner. They were married under the marriage ordinance. The petitioner was domiciled in the Netherlands but resident in Ghana. The petitioner filed in 1972 for divorce on grounds of cruelty. The couple lived happily as husband and wife until 1968 when they separated. The petitioner complained that the respondent frequently heaped insults on him in public. In 1972, the petitioner filed a petition for dissolution of the marriage. The respondent went to his place of work and harassed him by asking him to leave Ghana. Once, when the petitioner was in a meeting with his solicitor, the respondent went there and created a scene and demanded her marriage certificate from the petitioner. The respondent again threatened to kill the petitioner if he did not leave the country. It took police intervention before the respondent was removed from the scene. The respondent wrote to the head office of the petitioner's employers in Paris reporting that the petitioner had stolen certain properties belonging to the company. Investigations revealed that there was no truth in the respondent's allegations. The respondent again wrote a letter to the Freemasons' Lodge at Sekondi, of which the petitioner was a member, and castigated him as an unfit person to be considered for the post of master of the lodge. The complaint was dismissed as baseless. On another occasion, the respondent smashed the windscreen of the petitioner's car. She was convicted and sentenced for causing damage, sometime in 1969, while the petitioner was seated in an aircraft ready to take off for the Netherlands. The respondent entered with 2 policemen. The defendant pointed out the petitioner and the policeman who arrested him and took him to the airport police station. The aircraft left with his luggage. The petitioner was kept at the police station for about 2 hours before he was released. From the police station, the petitioner went to his office to complain about the incident. While there, an officer of the court came in, accompanied by the respondent, and served an absconding warrant on him. The petitioner was taken to the Accra High Court, where he was granted bail. It turned out that at the time that the police removed the petitioner from the aircraft, there was no absconding warrant for the arrest of the petitioner. The court held that the respondent's conduct was unreasonable and ordered a dissolution of the marriage. In Knudsen v. Knudsen, the petitioner applied for the dissolution of the marriage between her and her husband. Her reason was that the respondent had expressed the desire that they execute a deed of separation for no apparent reason. The husband also prayed for dissolution of the marriage in his answer on the grounds that the petitioner was violent, extravagant and jealous, and that the marriage had broken down beyond reconciliation. He stated that the petitioner had destroyed his medical books and destroyed his furniture, a slide projector and his hunting trophies. She also wrote letters to his employers in Kenya which prompted them to ask for his resignation. However, the March 1973, the petitioner and the respondent spent Easter with the children in Denmark, the respondent's home country. From Denmark, they cohabited in Ghana. In October, the respondent was arrested on absconding warrant at the petitioner's instigation. The petitioner subsequently withdrew her petition, but the respondent continued with his cross-petition. The trial court held that the conduct of the parties from May to September was inconsistent with their marriage having broken down beyond reconciliation, and that the single act of the petitioner getting the respondent arrested could not by itself be said to have broken down the marriage beyond reconciliation. The respondent appealed to the Court of Appeal. The Court of Appeal allowed the appeal and granted the cross-petition for a dissolution of the marriage. The court expressed the view that the husband succeeded in establishing that the wife behaved in such a way that he could not be reasonably expected to live with her. The court stated the behavior of a party which will lead to this conclusion would range over a wide variety of acts. It may consist of one act if it is of sufficient gravity, or of a persistent course of conduct, or of a series of acts of a persistent course of conduct, or of series of acts of differing kinds, none of which by itself may justify a conclusion that the person seeking the divorce cannot reasonably be expected to live with the spouse, but the cumulative effect of all taken together would do so. In Mensa v. Mensa, the respondent complained that her husband had behaved in such a way as to make it unreasonable to expect her to continue to live with him. She stated in evidence that they could not have children, but the husband refused to cooperate in finding a solution to their problem even though he was aware of her anxiety to have children. To make matters worse, he used the petitioner's barrenness to taunt and insult her. The petitioner therefore left the matrimonial house and did not wish to return. The court held on the issue of unreasonable behavior that it was not reasonable to expect a wife to live with a husband who behaved in the manner described by the petitioner. The court further stated that in determining whether a husband has behaved in such a way as to make it unreasonable to expect a wife to live with him, the court must consider all the circumstances constituting such behavior, including the history of the marriage. It is always a question of fact. The conduct complained of must be grave and weighty, and mere trivialities will not suffice, for Act 367 is not a Casanova's charter. The test is objective. In Opokuawusu v. Opokuawusu, a Ghanaian man married a German woman in West Germany in 1959. The couple moved to Ghana and had 4 children. In 1969, the wife refused to have sexual intercourse with the husband because of the husband's frequent demands for sex. The wife, who had had 10 pregnancies within a period of 11 years, was in constant fear of another unwanted child. She became nervous, and it became practically impossible for the parties to live together. Because she would not give him sex, he became inordinately jealous and did not want her to even have female friends. According to her, the husband became violent and his mere presence in the house frightened her. He would at times wake up at 2 or 3 a.m. shouting at the top of his voice. The situation became so intolerable that she had to leave the matrimonial home. She said that she did not love the husband anymore. The court held that a willful refusal by one spouse to have sexual intercourse might entitle the other party suffering to leave if in all circumstances of the case it could properly be regarded as grave and weighty, and if it had an adverse effect on the health of the other spouse. Such conduct might also amount to a just cause for leaving, even though it lacked the element of intent to injure. However, one spouse was not bound to submit to the demands of the other if they were unreasonable and inordinate or were likely to lead a breakdown of health. Thus, the spouse who suffered as a result of an unreasonable insistence on sexual intercourse would be entitled to leave the other. The husband's petition was refused, but the divorce was granted on the wife's prayer. Section 4 of the MCA provides that for the purposes of Section 2(1)(b), in determining whether the petitioner cannot reasonably be expected to live with the respondent, The court shall disregard any period or periods not exceeding 6 months in the aggregate during which the parties to the marriage lived with each other as man and wife after the date of the occurrence of the final incident relied on by the petitioner and proved to the court in support of his allegation. This means that if the parties have lived together as husband and wife for less than 6 months to attempt a reconciliation since the date of the last incident of unreasonable behavior, the fact of attempt at reconciliation should be disregarded in determining whether the petitioner could not reasonably be expected to live with the respondent. The 6 months cohabitation should not mean that the petitioner can now live with the respondent. The respondent can thus rely on the last incident. However, if the parties have lived as husband and wife for more than 6 months after the last incident, the petitioner cannot rely on it. Here too, the emphasis is on living together as husband and wife. In Ofori v. Ofori, the couple lived in the USA. They visited Ghana on holiday. While in Ghana, the husband petitioned for a divorce on the ground that the wife was rude and extravagant. Proceedings for divorce were started, but the couple returned to the USA before proceedings were completed. Upon their return to the United States, they lived together as husband and wife for 3 months before the wife left the matrimonial home with the kids. Counsel for the wife argued that the 3 months cohabitation had wiped the slate clean and therefore the husband could not rely on previous matters to prove that the marriage had broken down beyond reconciliation. The court held that the period of cohabitation was less than 6 months and therefore the husband could rely on the past. Unreasonable conduct. C. That the respondent has deserted the petitioner for a continuous period of at least 2 years immediately preceding the presentation of the petition. Desertion refers to the separation of one spouse from another with an intention on the part of the deserting spouse of bringing cohabitation permanently to an end without reasonable cause and without the consent of the other spouse. Desertion may result from a physical withdrawal from a place or a withdrawal from a state of things. The withdrawal must amount to a total repudiation of marital obligations, such as in Naylor v. Naylor. The separation must be continuous for a period of at least 2 years and must exist at the time that the petition is filed. If separation has ended at the time of the presentation of the petition will fail. The elements of desertion are de facto separation. This means a total and actual withdrawal from the performance of all marital obligations, a complete cessation of cohabitation. A refusal to perform one or two of the marital obligations is not enough. Thus, if a wife refuses to prepare meals for her husband but fulfills the rest of her marital obligations, the courts will hold that desertion has not been established. In Hopes v. Hopes, the spouses slept in separate rooms. The wife did not do any mending or washing for the husband, but he continued to have meals with the family and shared the rest of the house with them. The court held that there was insufficient separation of the household for there to be desertion. Also, in Bull v. Bull, the wife left her husband but later returned to live with him. Though she refused to have sexual intercourse with him, she cooked his meals and mended his clothes occasionally. The court held that there was no desertion. A withdrawal is not only a withdrawal from a place but withdrawal from a state of things. Therefore, spouses may be living under the same roof but may not be cohabiting. They may be living as 2 separate units under the same roof. The question to ask is whether the parties are living as 2 households or as 1 household. Animus deserendi. There must be animus deserendi on the part of the party who has withdrawn from the performance of his/her obligations. Animus deserendi is the intention to bring cohabitation permanently to an end. If the intention is to bring cohabitation temporarily to an end, animus will be absent. The respondent must have the capacity to form the required intention. Therefore, if a spouse is unable to form such intention due to insanity and withdraws from his/her marital obligation, he or she cannot be accused of desertion. The burden is on the petitioner to prove animus deserendi. A person who is insane cannot be in desertion because the animus deserendi cannot be formed as noted in Crowther v. Crowther, lack of consent from the other spouse. If a spouse withdraws from the performance of his or her marital obligations without the consent of his/her spouse, the conduct may amount to desertion. Thus, a spouse cannot complain of desertion when he or she has consented to the separation. Whether consent has been given is a question of fact. The consent may be express or implied, and it should be freely and voluntarily given. Desertion can take place even if the parties have not cohabited before and even if consummation has not taken place. Thus, if A and B get married and never cohabit, evidence showing that one of the parties never intended to cohabit with the other without a reasonable excuse and without the consent of the other party, their courts are likely to hold that there is desertion. As stated above, a withdrawal may be a withdrawal from a state of things. Therefore, cohabitation need not be a condition precedent for desertion to occur. If one spouse deserts the other but subsequently returns with a view to ending the desertion, the spouse will be presumed to have brought the desertion to an end. If the offer is genuine, the party refusing to accept the offer will be the party in desertion. He will be the party who intended to permanently bring cohabitation to an end without just cause and without the consent of the other party. In Spence v. Spence, for a fortnight before she left home, the wife engaged in open preparations for departure. Her husband was perfectly aware of her intentions and they discussed the division of their household goods. The husband did not make any attempt to deter his wife from going or to delay her departure. The husband was held to have tacitly consented to his wife's departure. It is important to note that there must in fact be an agreement to live apart. If there is no such agreement, it is irrelevant that one spouse was glad to see the other go. Thus, in Harriman v. Harriman, it was stated that desertion does not necessarily involve that the wife desires her husband to remain with her. She may in fact be thankful that he is gone, but he may nevertheless have deserted her. Therefore, the mere fact that the petitioner breathes a sigh of relief when the respondent has gone does not mean that she has consented to his departure. The petitioner must not do anything which suggests that he or she regards the marriage as over until the 2 years are up. Thus, for example, there must be no celebration of the respondent's departure by starting up an adulterous relationship with a third party, as the essence of desertion is that the petitioner is complaining of breach of a matrimonial obligation to cohabit, and so must in theory expect the respondent back any time during the 2 ensuing years. Entering a new relationship, unless it is not adulterous, would end the respondent's desertion by providing just cause for staying away. Another point to note is that consent must have been freely given. This if the consent is extorted under duress. It will not prevent desertion from running. In Holroyd v. Holroyd, a wife was virtually forced by her husband to sign a separation agreement because she thought that this was the only way she could obtain maintenance from him. It was held that the husband was in desertion. Also, if consent to separation is withdrawn, desertion will automatically begin. If the separation was originally intended to be purely temporary, e.g. for a holiday or business trip or until the husband obtained a job near the matrimonial home, the consent will lapse at the end of this time, and if one spouse then unjustifiable refuses to resume cohabitation, he will be in desertion as in Shaw v. Shaw, want of reasonable excuse. If a husband continuously beats up his wife and the wife leaves the matrimonial home, the wife will not be in desertion because she would have a reasonable excuse for leaving. In Winans v. Winans, the court held that keeping 30 dirty cats so that the house is uninhabitable is just cause. In Timmins v. Timmins, being overbearing, dictatorial and violent was just cause. In Gollins v. Gollins, it was held that being lazy and slovenly to the extent of driving out a moderately civilized spouse was just cause. There are 2 types of desertion: ordinary desertion and constructive desertion. With ordinary desertion, the spouse leaves the matrimonial home with no reasonable cause, with no intention to return and without the consent of the other spouse. Constructive desertion occurs where a spouse, by his or her conduct, forces the other spouse to leave the matrimonial home by engaging in conduct which makes it difficult for that person to remain in the matrimonial home. Examples of such conduct include: bringing a mistress to live in the matrimonial home. A husband's domineering and controlling character driving his wife away. The key difference between both types of desertion, therefore, is that with ordinary desertion, a spouse abandons the other spouse for no reasonable cause, whereas with constructive desertion, a spouse through expulsive conduct forces the other spouse to leave the matrimonial home. In the case of constructive desertion, the spouse who does the expulsive conduct would be considered as the deserter. In constructive desertion, factum and animus must also be established. The petitioner must therefore prove that the respondent intended to expel him/her from the household and to thereby bring cohabitation permanently to an end. Therefore, in Arku v. Arku and Abraham, the court noted that in constructive desertion, the spouse charged must be shown to have been guilty of conduct equivalent to driving the other spouse away. The conduct relied on may be the conduct of the offending party with a third party. The conduct relied on in this case was severe beating of the respondent by the petitioner. The petitioner also locked the respondent out of the matrimonial home. As a result, the respondent left the matrimonial home. All attempts by the respondent to reconcile with the petitioner were rejected by the petitioner. Accordingly, the court found the petitioner guilty of constructive desertion. In Hughes v. Hughes, the petitioner alleged that the respondent had treated him with cruelty and had also deserted him. The couple married and lived in London. When they returned to Ghana, they experienced some financial difficulties and depended on the goodwill of the wife's father. The petitioner was employed as an engineer while the wife worked as a nursing sister in Accra. The wife moved to Agogo for a better paid job in 1967. The petitioner then moved to live in a small room in his family house. The room was not suitable for a family of 4. They continued to visit each other until the husband stopped visiting. His reason was that the respondent did not receive him well and made unkind remarks about his dressing and financial position. The court held that for the conduct of the wife to amount to desertion, the court has to be satisfied that it was an unjustifiable withdrawal from cohabitation and that she had the intention of remaining permanently separated from him. Where a spouse has agreed that the other spouse could leave, he could not complain that the other was guilty of desertion as separation was by consent. In Dickinson v. Dickinson, a husband brought his mistress into the matrimonial home and the wife therefore left the home. It was held that the husband was in constructive desertion. Also in Morse v. Morse, the husband insisted on retaining in his employment a female employee to whom he paid attention, and whose company he preferred to that of his wife. The wife left the matrimonial home and it was held that the husband, having made it practically impossible for the wife to stay with him, had constructively deserted her. Further, in Patching v. Patching, the husband was a devout Jehovah's Witness. The wife was of delicate health and sensitive disposition. The husband neglected her in order to pursue his religious beliefs and he desired her to be governed by the rules of his sect. It was held that the husband's conduct involved an invasion of the wife's personal freedom which went beyond anything which she might reasonably be expected to put up with in the ordinary course of married life. And that when she left the husband, it was the husband who was the deserter, per Section 5(1) of the MCA. In calculating the period of 2 years, the courts should disregard any periods less than 6 months that the parties resumed living together as husband and wife. The rationale is to facilitate reconciliation between the parties, and to give them an opportunity to reflect on the state of their marriage, without prejudicing proceedings for divorce if such proceedings become necessary at a later stage. Section 5(2) further states that for the purposes of Section 2(1) SE, the court may treat a period of desertion as having continued at a time when the deserting party was incapable of continuing the necessary intention if the evidence before the court is such that, had that party not been so incapable, the court would have inferred that his desertion continued at that time. Some of the circumstances of termination of desertion are, by the parties subsequently agreeing to live apart. Resumption of cohabitation for a prolonged period, by the deserting spouse making a genuine offer to resume cohabitation which the deserted spouse unreasonably refused, supervening consent. Good cause for separation supervening i.e. by the deserted spouse. Subsequently providing the deserter with reasonable cause to stay away, for example, where she commits adultery which comes to the notice of the deserter. D. That the parties to the marriage have not lived as man and wife for a continuous period of at least 2 years immediately preceding the presentation of the petition and the respondent consents to the grant of a decree of divorce. Provided that the consent shall not be unreasonably withheld, and where the court is satisfied that it is so withheld, the court may grant a petition for divorce despite the refusal. Spouses could be living under one roof but in 2 separate households. Each party carries on with life as if the other was not present. Indeed, there is no consortium and all marital obligations are withdrawn. When this carries on continuously for a period of 2 years, the parties will be deemed to be living apart provided one or both parties regard the marriage as at an end. Mere separation is not enough. There must be proof that at least one of the parties believed that the marriage had come to an end. In Addo v. Addo, the husband and wife married in 1958 but ceased to live as husband and wife in 1969. They lived under one roof, but there were in effect two households. The court held that the marriage had broken down beyond reconciliation. The husband charged that the wife had an ungovernable temper, she was persistently nagging him, and that he had not had intercourse with her in a long time. The wife refused the husband's consent to a grant of a decree of divorce as required by Section 2(1)d. The court held that a willful refusal to have intercourse at all would entitle the party suffering as a result of it to leave the other in such conduct if it injured the other's health. As in the instant case, would support a charge of cruelty and also a charge that the behavior of the petitioner was such that the respondent wife, although she did not want a divorce, could not reasonably be expected to live with her husband. Whether or not consent was being unreasonably withheld was a question of fact in each case. The test was objective, i.e., whether a reasonable spouse, placed in the situation of the particular spouse, would withhold consent. All the facts ought to be looked at. The deliberate behavior of the husband in the instant case, in persistently refusing the wife sexual intercourse over a long period resulting in injury to the wife's health, constituted such unreasonable behavior that the wife ought not to be called upon to endure it any longer. Consequently, the wife had unreasonably withheld her consent, and since the marriage had broken down beyond reconciliation, a decree would be granted notwithstanding the refusal of the wife to give her consent. Note that positive consent is required and not a mere failure to object, per Section 6(1). For the purposes of Section 2(1)d, the court must be satisfied that a consent to divorce has been given by the respondent only after the respondent has been given such information as will enable him to understand the consequences of his consent. 2. Where the only fact specified in Section 2 upon which the petitioner relies in support of his petition is that mentioned in Section 2(1)d. The court may, on application by the respondent at any time before the decree is made, dismiss the proceedings if it is satisfied that the petitioner misled the respondent, intentionally or unintentionally, about any matter which the respondent took into account in deciding to consent to the grant of a decree, that the parties have not lived together as man and wife for a continuous period of at least 5 years immediately preceding the presentation of the petition, or, under this section, it is enough for the petitioner to establish that the parties have not lived as husband and wife continuously for 5 years. Consent of the respondent is not required. The commission of a matrimonial offense need not be established. The marriage will be dissolved if the petitioner is able to establish a 5-year separation. The fact that the respondent has not committed any matrimonial offense is immaterial. Thus in Cotai v. Cotai, the parties were married in 1962 and had 2 children. They returned to Ghana in 1967. The petitioner lived in Kumasi, and because they could not find a suitable accommodation, the respondent and the children remained in Accra. The respondent visited the petitioner only twice between 1967 and 1974. Once she stayed in the petitioner's house but in separate rooms. In 1974, the husband petitioned for a divorce on the grounds that the parties had not lived as husband and wife for a continuous period of more than 6 years and that the marriage had consequently broken down beyond reconciliation. He further averred that he was not prepared to continue with the marriage. The respondent, however, asserted that she was still in love with the petitioner and that she was willing to make attempt at reconciliation. The court held that the petitioner was entitled to a divorce and stated that once the facts are proved bringing the case within any of the facts set out in 2(1), a decree of dissolution should be pronounced unless the court thinks otherwise. In other words, the burden is on the petitioner to show that special grounds exist justifying the exercise of the court's power. Once he or she comes within any one of the provisions in Section 2(1)(e) and (f), the presumption is in his favor. Proving one of the provisions without more is proof of the breakdown of the marriage beyond reconciliation. The court further stated that proof of 5 years continuous separation enables the marriage to be dissolved against the will of a spouse who has not committed any matrimonial offense and who cannot be blamed for the breakdown of the marriage.